Order. I want to welcome everyone here this morning, and I do see some new faces in our audience. I want to first acknowledge a piece of information that will be coming to each of the House members and the Senate members, and this is a great resource that our hospitals have put out for us. One thing that is so valuable, and I want to stress this to the committee members, is the fact that it has a wonderful glossary in it that will help you with the terms involved with health care. So I wanted also to let you in the audience know that this booklet exists. It's a very valuable aid to all of us. To the House members, my understanding it will be on our desk when we go back into session, perhaps tomorrow. So I just didn't want you to take it, and sometimes you put it in file 13. Please keep it in the handy file so that it can be used. So, and I want to thank the hospitals associations for putting this together because it's a very valuable tool for us. It's called Hospitals 101, and that's what it is. So thank you very much for doing that in behalf of the state of Georgia and its citizens. Today, also to our committee members, we again will be having a meal tomorrow evening for those of you that are new. Our committee, since we're Human Relations and Aging, will be going to participate in an exhibition and a meal that will be served to the committee members at the Dialogue in the Dark, where I think it's a very appropriate place for our committee to go and to dine and experience some of the things that possibly could come about and it hits all ages with blindness or impaired vision. So we're excited about having the opportunity to go there. I wanted to again just follow up with those in the audience to let you know that we are trying to educate ourselves in various ways to the needs of the citizens of the state through Human Relations and Aging. This morning we are here in regards to the Bill 278, and I see that we have the author here to explain the bill. As we go forward, we'll be asking questions, and again, if anyone thinks they may want to speak on this bill, I hope that you have signed in over here. With that, Representative.
Thank you, Madam Chairman and the committee. First of all, let me say thank you for taking the time to hear this bill. And to the committee members, I know this is a very delicate issue that we're going to be discussing. And for some, it can be a very difficult vote. I understand that. But briefly, I'm just going to kind of go through the bill, explain it, and be more happy to answer any questions when we complete that. But in Section 1 of the bill,
Will you tell us what you're speaking from?
I'm sorry. Yeah, as myself and Representative Benton is talking, I think this is the 15th substitute on the bill, but it's LC number 285634S.
Let me hold you up. We do have some copies of the possible substitute to the bill, but what is being brought to us today, if you'd like to have a copy, we may not have enough for everyone to have one. If you would please share, that would be wonderful. If you'll give them just a second to get that.
That's fine.
For the committee members in your folder, there is an explanation in regards to House Bill 278 as it was introduced. There is also a summary for you with the House Bill 278 with the LC 285634S that you may follow. With that, if you'll continue.
I guess I'll go in a little bit more detail. I've been studying this issue since the summer, and it's gone through many changes from having the criminal aspects to the bill to civil penalties to the bill, and trying to work with different groups to come up with a compromise. At the end of the day, there's truly just not a compromise that can be reached because it is such a delicate issue. So what I've done is try to bring this down to the most purest form of the bill we can and the shortest version of the bill that we could to accomplish the same goal. But in Section 1 of the bill, starting on line 13, it starts giving definitions. The definition for the attending physician, line 16, health care, and gives its meaning and where it's found at. Gives the definition for nourishment and hydration. The meat of the bill comes on line 19. This starts referring to the Advanced Directive for Healthcare. What we're doing under the new Advanced Directive is stating that unless it is specified in that Advanced Directive, you would not be able to remove hydration or nutrition from a patient unless it needs to be removed for a medical procedure. Now, a lot of us, there's been a lot of comments about how about a living will or a power of attorney. In 2007, Georgia replaced the living will with the Advanced Healthcare Directive. Anything after 2007 would have to be the Advanced Directive. Anything before would still be valid. On Section 2 of the bill, lines 29 through 31, it just states nourishment and hydration. It shall not mean a life-sustaining procedure, medical treatment, or health care. Nutrition and hydration is not a medical procedure. This is just giving the body what it needs to live on. Section 3 talks about a healthcare agent. If you have a healthcare agent, he or she may not choose to refuse or withdraw the nourishment or hydration unless given authority in the Advanced Directive for Healthcare. This was brought to me by a constituent in my county. If it sounds very familiar to a case we're probably all familiar with several years back in Florida with Terry Schiavo, it's very similar to that. In this state, in our humane facilities for animals, humane shelters, we give those animals water and food. And death penalty cases, up to the last day, they get to choose their last meal that they want before we move forward. Food and water is the basic essentials for life. Nowhere in this bill does it state if you're on a ventilator, if you choose to end that procedure by pulling the proverbial plug, that's a decision that can be made. But if you're not on any medical procedures or machines, water and nutrition, if you're still living with that, your body's showing a will to live. And we firmly believe that no one should have the right to starve or dehydrate someone to death unless it's specifically spelled out in that Advanced Healthcare Directive. Looking at many cases in the past, there's not much of a worse way to die than being dehydrated or starved to death. Again, if that's your choice, you can look at this as the ultimate individual responsibility bill that you'll ever vote on, because it is an individual responsibility to make sure, if that's your wishes, to make sure this is taken care of. That's what the bill does. I said it's a much shorter version than what we had in the past. It gets straight down to the basics. I know there's a lot of people opposed to this bill. I respect their opinions. Respect the opinions of this committee. This is a committee process, and I respect every one of your decisions and what you may or may not do on this bill. But with that, Madam Chair, I'd be more than happy to answer any questions.
Do I have anyone with a question? Tom.
Thank you, Madam Chairman. Representative Beard, and I looked over the bill. I've got a concern starting on line 41, the new language 41 through 44. You mentioned a while ago that there was no worse way to die than to be denied nourishment or hydration. Is there a worse way to live?
I don't know. Never been in that position, and hope I would never be. But if that's the case, then hopefully my wishes be followed.
But in these lines 41 through 44, if you don't have a living will or somebody has power of attorney for you, and you are laying there, you're not on a ventilator, but basically you're in these 41 through 44, you're saying that your wife or your child, whoever is your next closest kin, cannot make that decision for you. Is that, am I reading that correctly?
Under those lines right there, we're specifically talking about a healthcare agent, and that is usually chosen through your advance directive.
What if you don't have an advance directive?
Then again, the refusal of hydration or nutrition would not be allowed. As I said before, I know this is a tough decision. It's a delicate issue, but that's
even if
what
there's
like.
no hope for you to get any better than what you are right there at that time.
There's a higher person or individual or being higher than me that makes that decision of what my hopes of survival would be at that point, and that would be God. So I cannot make that decision. As I said, this is a very delicate issue, and it's a very important issue. That's why this is very important. That's why I said it's the ultimate individual responsibility bill.
Well, let's turn it around, and it's your wife that's in the bed, and she doesn't have a living will, no power of attorney. Would you still be comfortable with this right here, knowing that she would not want to live the way she is right there?
One, I said, if you still provide water and nutrition and the person is still living, to me, there's a will for that individual to live that's still taking place inside that body.
Well,
would I ever want to be put in that situation? No. And yes, you're talking about a very tough decision.
You know, there are people that say that I'm gonna kill myself by holding my breath, and of course they hold their breath until they pass out.
It's impossible to do.
And automatically you start back breathing again because the body's saying no. But do you understand where I'm coming from? My question.
As I said, I completely understand where you're coming from, and that's why I said this is a very tough issue. It's a delicate issue, and as I said, it's a tough decision for this committee to make, and because those comments that you made are the ones that's going to be weighing upon every single person's mind when they make a decision on whether they're moving forward on this bill or not.
Okay.
So I said we tried a lot, but it is what it is, and this is the purest form that we could come up to.
One other thing, your wife is in the hospital. She can't speak for herself. The cost that the hydration and so forth that your insurance has played out. I'm concerned with what it would do to the rest of the family.
I understand that, and since you mentioned my wife, I make this. There's not a cost threshold to say I'm going to go ahead and starve or dehydrate my wife to death.
Okay.
That's just not an option.
All right. Thank you, Madam Chair.
Any other committee member with comments or questions to the author? What number is that? Okay, Representative.
You know, sitting here and having seen over the years, I guess when you get to a point that you see so many people moving in a non-physical direction, this is a very, very difficult decision to make here for us. I don't know what I would do. I've had the opportunity, of course, to observe other people. Fortunately, it's never happened in years to an immediate family member. But, Beard, I'm just wondering, I know you cited one example, and I have a lot of respect for you, even though we've differed on things over the years. I admire the way you go after things. I mean, you're very passionate about what you do. My concern is, have you consulted medical people on this? Have you talked with people that are involved in this on a daily basis?
Sure.
What is driving? I know you said you had one example in your constituency area of an individual that's concerned about this. But I'm wondering what the medical community is saying about this, and how many people in the religious community, whether you're talking about Christian, Muslim, Hindu, it doesn't matter, because this has such a broad-based a possible effect on people. I mean, I say this is really, really, really interesting. And I'm sitting here talking to my colleague, and I don't know what to do on this. And I'm just wondering what other people feel about it. And I'm almost at a place, Bearden, that since this is going to have such a wide range impact on people, that I'd like to see more evidence that this is needed. And at the proper time, Madam, I'm being honest with you, Tim, and I love you dearly, my brother. But I'm going to ask that this be tabled because there's so much more that needs to be investigated on this. Because I have family members that might be faced with the same situation one day. And I hope that you'll respect my request because I like to see more evidence that this is needed, and to make sure that we're not getting into an area that we'll look around a few months or a few years from now that we'll totally be sorry that we've made this decision.
Well, again, I have a strong feeling you're going to hear from a lot of people here in the next few minutes from the sign-up sheet that's out there. We have consulted. I said this is something I've been looking at very closely since the summer months. This bill has changed so many times over the months, trying to strike a compromise. I mean, we've talked from the attorneys from the Medical Association in Georgia to the Georgia Trial Lawyers Association, so we covered both spectrums. And both would have concerns on certain areas of what we're trying to do and from the previous bills written. Again, I can't say enough. This is a tough issue. And we're elected to represent our constituency. And that's why this bill was brought up. It's brought to my attention. You know, there's a lot of information out there. It is a tough decision when you finally make that choice if you're going to withhold hydration and nutrition from an individual. Again, that is not medical care. But more importantly, as I told the Madam Chair, I greatly appreciate y'all looking at this matter, and I will respect whatever the decision the committee comes to, because I would expect the same on my committee.
Representative Heffernan, this is not the proper time, but I will recognize you at the proper time.
Then, Madam Chair, may I, to my colleague, let me apologize for that. I think I kind of jumped the gun because you did remind me we do have to hear from other people.
Yes,
and I apologize to you, Tim. I mean, Representative Bearden, about that.
No, this
Sorry
is
about
fine.
that.
This is fine.
Good friend for years, so that's no problem whatsoever.
Any other comments or questions to the chairman in regards to his bill from our committee members? All right, seeing none, the sign-up sheet, where is it? Right there. If you wish to speak, I asked you just to come forward if you want to make comments about the bill, and we've got a chair right there.
Thank you, Madam Chair and committee.
I'm going to just sort of see how long it's going to take us, but please try to limit your remarks to 3 minutes in regards to what you may want to say about the bill, so that we can get through, and then if we have questions, we'd certainly want to address those to each of you. So as we go through, I see several individuals, so if you just want to come forward and speak, that will be fine. Identify yourself and also identify from what group that you might be with. Thank you.
Madam Chair, members of the committee, my name is Steve Graddick. I'm a resident of Bowden, Georgia, lifelong resident of the state of Georgia. Own and operate radio stations in the West Georgia area. I am probably, or I am, I suppose, a large part of the motivation behind this piece of legislation. Let me say at the outset, I understand that many of our families have these difficult end-of-life situations and issues. And my situation that was really the catalyst for this legislation, Madam Chair, in order to describe the situation that happened to myself and to my family, which I think is, of course, just one individual and doesn't necessarily make for good legislation, but I think is very illustrative of the deficiencies in the law. And I would like to ask if I could have an extension of the 3 minutes in order to describe the situation that happened to our family that may and hopefully will point out the need for this legislation.
Please continue, and we'll extend it to a 5-minute period so we'll have adequate time for others to speak to the bill in regards to their thoughts, and then if we have time, we'd certainly come back if you don't finish.
Thank you, Madam Chair, and please feel free to interrupt me and stop me at the prayer. As a radio guy, we tend to watch the clock pretty good. Speaking of radio guys, my uncle, Robert J. McGarrity, is really the core of this issue. I'm very proud to say posthumously he was inducted to the Georgia Radio Hall of Fame last year. In July of 2007, he had not been taking really good care of himself in that he had started having pains in his abdomen. He collapsed one Saturday evening and was taken to Gwinnett Medical Center Lawrenceville. First part of the week, he had half of his colon removed. And I come from a medical family. I had ulcerative colitis for 10 years and then in hospitals for 14 different times, so I was familiar. He did very well for an 86-year-old man. The second part of that week, he had to have a second operation, have the entire colon removed. The Monday of the following week, his pastor of 30 years, Dr. Ronnie Spillers, visited him that morning, Monday morning, and found that the feeding tube and the fluids had been removed. And Ronnie was appalled. Why? And so he called his daughter, my cousin, and she came and she insisted that the feeding tube and the hydration be replenished. We were really confused. The second week, on Thursday, we had a family meeting. And Uncle Robert's wife of 22 years assured us that she would do everything for Uncle Robert's rehabilitation and care. He was on a ventilator, but he didn't have cancer, didn't have a heart problem. He had his mind. At 86, he was driving right up until the time, and safely, I might add, to the time he collapsed. The next week, he was removed from the third week. He was removed from the ventilator and did fine. He breathed on his own. During that time, we couldn't understand. Beth, his wife, was always seemingly in his face saying, "Do you want to go to heaven? Do you want to go to heaven?" And as a lay preacher, most of the time the answer is yes. But he was on morphine. He was in a lot of pain. So we really didn't understand what was going on. The fourth week, we were very proud. He was taken upstairs to a private room, and another attempt was made to remove the feeding tube and fluids. We didn't understand why, but we opposed that successfully. Uncle Robert only had $150,000, which is a lot of money actually, in account. But Beth had broken her leg, and she was in a hospital, and her siblings from her previous marriage were concerned about the finances for long-term rehabilitative care. Saturday morning of that week, he was transferred to Peachtree Christian Hospice in Duluth. And at that point, I went into like overdrive. Why? I mean, obviously, it wasn't terminal. Beth had successfully removed the first doctor, and through the ethics committee of the hospital had acquired another doctor. And so now he was taken to the hospice rather. And so red flags went all the way up. I contacted the legal counsel of the hospice, and they said he was in a coma and that he was not being given food or hydration. Now, his wife of 22 years did have durable power of attorney and did have it living will at that time, 2007, and I was the nephew. The daughter was engaged. She met with the administrator Monday morning. I contacted Superior Court in Gwinnett County and got basically no response through the weekend because it was the weekend. And being the nephew, trying to get some sort of stay to reestablish food and water was not going to be possible until Monday morning. The daughter communicated with the administrator. At that point, that day, my father, my sister, who's a physician, very proud of her, and myself offered to Beth, the wife, that we would take care of Uncle Robert, and we'd take all costs from there forward. He could come to Carrollton, Bowden, and we would take care of him if she would just let him live. She rejected that offer. On Thursday, my uncle died. My uncle was getting better. Actually, he was doing great. For 86, to have your colon removed and have peritonitis, he was doing great. But he only had $150,000 in the account, and she was concerned, and her siblings, that there wouldn't be enough money to pay for his rehabilitative care. So along with the hospice and the hospital, food and water was withheld, and I believe a coma was induced, and he's no longer here. $150,000. He didn't have cancer. He really wasn't, so he's in really good shape. Didn't have heart problems, had his mind. And I think, ladies and gentlemen, with all due respect, I think the law should protect those, even in our own families, that would do us harm and kill us. And unfortunately, that was the case here. If it's in the advance directive, do you want to withhold food and water? That's fine. That's cool. But if it's not, it's an area that we're allowing loved ones to take advantage of. Food and water is not medical treatment. So I thank you for your time for my 5 minutes. I appreciate your examination of this legislation. It's been since 2007. We've been pushing forward, and I hope you will understand it's just simply about allowing someone to have a natural death. Thank you very much.
Do I have any questions from any of our committee members that you would like to address at this time?
Ms. Purcell, this is just the smallest of comments. I want you to know that your uncle wrote my high school fight song.
You're kidding. Go Black Knights. Thank you.
A
I
great
didn't know
memory.
that. Yeah, he was, and we got him into the Hall of Fame after the fact, of course, last year, and they played a snippet of that at the Georgia Radio Hall of Fame, so that's really good. He went on every road trip, get this now, for like his entire life, 40 years. He married 14 couples, he buried 12. When he retired, he became a greeter, not at Walmart, but at Kmart. And I mean, this guy loved people, and I just think, you know, that it was the wrong way for him to leave this earth. Although he's in heaven, he's with the Lord, and we're thankful for that. But thank you for that.
Any other comments? Very positive. Thank you. Thank
Thank you so much.
Yes.
Madam Chair and representatives, committee members, thank you for your time this morning. My name is Dwayne Hack. I'm a constituent of Tim Bearden. I live in Carrollton, Georgia, and I'm also a member of Georgia Right to Life as well out in West Georgia. And Representative Bearden brought up the case concerning Terry Schiavo. I really don't want to allude to that because that was a Florida case, but yet I think some of the premise behind that we can see and learn through that as well. Prior to the case in the late 90s, the Schiavo case, if a person who could no longer speak for themselves, the guardian or family member could not approach the court and convince the judgment or the judge that removal of the feeding tube is what the individual wanted. That wasn't allowable. As a matter of fact, it was even called hearsay during that period of time. No one could prove without absolute certainty what the patient's actual wishes would have been without a written, clear directive. In this case, in the same case back in November 2002, it was stated by the overseeing judge, which was Judge Greer during that period of time, and he said this, and I really want to dwell on this for just a minute. The real issues in this case, however, deal with treatment options, is what he said. Whether or not they will have any positive effect as to the significant improvement of quality of life. And I guess my challenge to myself as I read through this, and of us as well, is where do you draw that line? Is what is a significant improvement in quality of life? It's a slippery slope that unfortunately we've fallen down on. In this statement, it was ruled as law and upheld in the state of Florida. Again, I'm not comparing us to Florida. I'm just trying to hope that we can learn something by what came out of there. In that statement, it was ruled and upheld. We discovered the disabled, the handicapped, the sickly, the elderly are being told by our court systems today, your life is not worth living. It has no intrinsic value if it doesn't mean our own minimum standard of quality of life has been reached. Where do we draw that line of what is the quality of life that can be reached? We have allowed the court system to be the ultimate judge in establishing life or death for one unable to make the decisions. And let me close with this. One of the statements that I continually reading as I study this situation is it talks about the dignity of life. I think it was brought up this morning in conversation about passive death, painless death, or maybe gentle death during that period of time. And as I was out on a treadmill this week for up in my upstairs in my workout room, and then they showed a commercial, and it was for Feed the Children. And as I was watching this commercial, it showed, and I think it was the blonde-haired lady, Susan Smothers, I think her name is. She says, "Can you not give us 30 cents a day to help these individuals, to help these people, these children that are dying and starving from nutrition and hydration. And it's sent up to me as I looked at the picture, and in your mind, I think you all have seen this, we all have seen that commercial, and you see the children sitting there, and you see their bones piercing through their sides, you see their eyes falling back, you see their lips dry. And I said to myself, that's what we're fighting for today. We're fighting that an individual doesn't have to go through the removal of nutrition and hydration. That's all we're asking today, is for you to please consider that commercial when you review this. Feed the Children commercial about removing nutrition and hydration for an individual, because that picture in our mind is what we see when people die from the lack of nutrition and hydration. Thank you, Madam Chair.
Do we have any comments or questions from committee members? Seeing none, thank you so much.
Thank you, ma'am.
Do we have someone else that would like to speak at this time?
Good morning, Madam Chairman and representatives of the committee. My name is Mary Boyert, and I am here representing the Catholic Archdiocese of Atlanta. My position there is the Respect Life Director of the Archdiocese, so I'm here to share with you some of Catholic Church's position on this bill, and just as a little background, our teaching on these matters. The basis for the Church's teachings, all teachings on social justice issues, including the life issues, is that of the dignity and value of every human life. That's the basis for any decisions that we make when we look at legislation or any of these matters. And we believe that all human life should be protected and respected from the moment of fertilization until natural death. Therefore, we do not support the direct taking of human life through abortion, euthanasia, mercy killing, suicide, or assisted suicide. We are here in support of House Bill 278. We do have one small recommendation for some of the wording. We also teach that individuals, persons have an obligation and responsibility to take care of their own health care. And that would include good medical care, that which is proportionate, or ordinary care that has a reasonable hope of benefit and doesn't entail excessive burden or impose an excessive expense on the family or the community. At the same time, however, we do recognize that an individual has the right to refuse medical care that would be considered extraordinary or disproportionate to the circumstances. And one of the things Mr. Hack mentioned, the Terry Schiavo case, and that created obviously a huge interest in this issue. And shortly after that case, the Catholic bishops of the United States sent a letter to Rome, to the Vatican, to have clarification on provision of food and hydration. And the answer came back from Rome after due deliberation that nutrition and hydration is to be considered ordinary care, not even to be considered medical care, however it's provided, and that should be provided to the patient unless in certain rare circumstances where the nutrition and hydration is not beneficial or it's disproportionate to the case. So we would consider in most cases nutrition and hydration to be ordinary medical care, and that's why we support the bill. The change that we would recommend is that you consider adding some type of wording, and I have a sheet that I can give to you, Madam Chairman, that would say that I believe on the new version it would be on line 23 after the word hydration, where it says under no circumstances shall an attending physician deprive a person receiving health care of nutrition, nourishment, or hydration. And then it says, unless the attending physician determines that such deprivation is necessary for medical treatment. We feel that it might be better to actually spell that out. So we suggest you may say something along the lines of, unless the attending physician, using reasonable medical judgment, determines that the nutrition and hydration cannot be assimilated by the patient or cannot be administered to the patient without causing excessive physical discomfort to the patient or creates an excessive burden or expense to the patient or the patient's family. So this, we feel, might cover those conditions where actually the nutrition and hydration is detrimental to the patient rather than keeping them alive. So, this would be what our suggestion would be. And other than that, we support the bill, and we feel that this would be a very, very good addition to Georgia's laws to clarify these circumstances so that a person is not starved to death unnecessarily. Thank
You're
you.
certainly welcome to leave your
Okay.
suggestion with us. That would be
Okay,
fine.
great, thank you.
Any comments or questions from our committee members? Okay, seeing none.
Good morning. My name is Jennifer Hale. I'm the Executive Director for the Georgia Hospice and Palliative Care Organization. I've been a registered nurse for nearly 20 years. I've worked primarily in end-of-life care and care of the elderly, the very frail, the dying. And I hope nobody brought rotten fruit because I will be the dissenting voice here today. We do not support...
Stop you there.
Yes, ma'am.
There will be no throwing of any fruit or anything else in this committee.
Yes, ma'am.
You're here to give testimony however you believe.
Thank you.
And we welcome those thoughts. So I want that to be clear in this committee. So now you may continue with your 6 minutes.
Thank you, ma'am. I appreciate that. This is an extremely serious issue. And as a hospice and end-of-life care professional, we often bring levity to situations in which there are very serious discussions. What I would like to say is that we have developed, based on an abundance of current professional literature, both in the medical and in various ethical situations, that this particular bill would restrict the right and autonomy of individuals and the best medical care utilizing current clinical standards in providing care that meets the individual needs of patients. We really have an obligation, as other very eloquent speakers have mentioned, we have an obligation to do what is right and what is good for each individual patient. It's a very sad story that you brought to us, and I'm sorry to hear that.
You're speaking to the committee.
Yes, ma'am. That particular case that was brought here is an individual case. And there are many such individual cases that occur every day throughout the state of Georgia. They don't always end that way, and they don't always have the same situations, but each case must be considered individually. Based on all of that current clinical standard that exists, we believe that artificial nutrition and hydration, which is what we are talking about, is a form of medical therapy. It must be applied by a clinician. It must be monitored and given by someone with clinical experience or training. And in withdrawing it, it must be considered in the form of a medical intervention. We talk about natural death, and natural death would occur if those interventions were not applied. So we must consider them in the forms of having been implemented. The right of the individual to accept or refuse treatment is well documented. It's ethically supported as an autonomous activity. If every person in this room and in the state of Georgia had an advance directive, there would be no question. We would not be arguing about this particular case. But unfortunately, that is not the reality that we live in. Medical care today is very complex. These situations in which clinicians and patients and families find themselves are heartrending in many circumstances. And creating a bill that would restrict the ability of physicians, patients, and families to have a conversation about what treatments are right and for how long would really do a disservice to the patient consumer community as well as to the medical community. And I ask for you to consider those different points. We do have a position statement that we have provided to Representative Bearden. If you would like copies, I'll be happy to provide those with you as well.
You should provide those to us, please.
Yes, ma'am.
Any questions from our committee? Yes.
Thank you for being here today. Do you think that this is the same type, when a person is really ill and sick, they have a form they can fill out of, and with the right to live, the right to be resuscitated? do you think that this coincides with the same thing as a right for them to have nourishment or hydration?
I'm not sure I understand your question. There is a form called a do not resuscitate form, and that is part of an advance directive overall, which directs care providers to withdraw or withhold CPR. Artificial nutrition hydration is obviously not the same thing as CPR. And the purpose of an advance directive is, of course, to provide direction to caregivers, family, physicians, et cetera, about what treatments you do or do not want applied. Your advance directive can say, I want everything done, and I want it done for as long as possible. Or it can say, I want this done, but not that. And that is the purpose of the advance directive. Our concern is that in the absence of that advance directive, where there is no clear direction from the patient, we must have an opportunity to use substituted judgment. It has been ethically supported and supported in courtrooms across this country, and including the Terry Schiavo case and so on. We have to have the opportunity to utilize substituted judgment.
Does that answer your question okay?
Okay.
Any other questions from our committee members? Seeing none, thank you so much. State your name again for us, please, in your group.
Yes, ma'am. I'm Jennifer Hale, and I'm with the Georgia Hospice and Palliative Care Organization.
Thank you. Anyone else?
Good morning, members of the committee, Madam Chair. I'm Sheila Humberstone today on behalf of the Alzheimer's Association Georgia chapter. I rise today to shed some light on some challenges that we have with the bill. The Alzheimer's Association represents the 200,000 Georgians living with Alzheimer's disease, as well as the 350,000 caregivers. We have a real concern about this bill for the mere fact that, like the previous speaker said, most people don't have advance directives. My mom has late-stage Alzheimer's, so we're going to be making these decisions probably very shortly. Fortunately for my family, as soon as my mom was diagnosed, we sat down at the table and had a real discussion about what her end-of-life decision-making would be. We did that at my urging. Most families don't know enough to have those kind of conversations. I'd also like to tell you that a year and a half after we had that conversation, when we felt like my mom's faculties hadn't changed that much, I wanted to sit down with her and document some conversations, sort of her life lessons for me while she still could. I thought she still had plenty of ability to reason, to write, and to read. I was struck by the fact that while she could still communicate verbally, she had lost all of those skills. If we had waited 6 to 9 months longer to have the conversation about end-of-life decisions, I don't think she would have been able to participate. Our concern with this is with an Alzheimer's patient, if they are hooked up to a feeding tube or a hydration tube, it is very upsetting to them. The next step then would be to restrain that patient to a bed. That's not a quality of life. Once an Alzheimer's patient is restrained in a bed, which is not allowed in most nursing homes anyway, if they are restrained, they're going to get agitated. When they get agitated, they put them on medication to numb them out. I would argue that that is not the best way to leave this world. My dad has been taking care of my mom for the last 7 years. He feeds her with a fork and spoon. He helps her toilet. He helps her get in and out of bed. We have an advance directive, but many of the 300,000 plus caregivers don't. They're allowed to take very good care of their loved one every day through this hideous disease, toileting, changing, and everything else. But at some of the critical decision makings, this bill would thwart their ability to make some of the most important decisions and act in the most important way for their family. I believe a healthcare agent is responsible enough to be able to make this decision on their behalf of their loved one. So I just want to tell you today that we oppose this bill. I urge you to have some real thoughtful consideration about its impact on everybody, regardless of their health and well-being. Thank you. Any questions?
Any questions from our committee members? Seeing none, thank you so much. Anyone else?
Hello. I'm Dr. Shantae James. I'm a pediatric resident at Emory. I went to medical school here at Morehouse School of Medicine, and I'll be finishing my residency on June 30th. I'll be doing private practice here in Georgia. I have the opportunity during my training to work in the pediatric ICU at Eggleston, and I kind of had a question, I guess, about the bill of how it relates to children who don't have advanced directives, and often parents don't even have the idea to think about an advanced directive for children. And I see tons of kids that come in with traumatic brain injury that aren't necessarily on a ventilator, but they are requiring medical intervention by feeding and nutrition. And I think that a lot of people are calling it food and water, but I think it's a lot more complicated than that. It's not just food and water. Oftentimes it's either a G-tube that you're providing a complex blend of nutrition that you have to actually make in a pharmacy, or it's TPN, which is a liquid that you put through your IV that gives you nutrition that has tons of complications like TPN cholestasis. They get hyperbilirubinemia, and it's more than just giving somebody some food and water like you would, like an animal in a shelter, like it was referred to. It's a lot more complicated than that. So I think that it actually is a medical intervention, and it should be thought of that way, as an artificial way to prolong life. And I guess that's just really my question, and my concern is that what would I do when I have children in the ICU that have had traumatic brain injury, that we tell the parents they're not on a ventilator, but this is not going to get better. And children, really, of all the patients that are in the hospital, have the best outcomes when it comes to traumatic brain injury. Children just kind of heal faster and better than older adults do in general. But when we know it's not going to get better, for a parent to not be able to say, I don't want my baby to live like this. I don't want my toddler or my 3-year-old to have to do this for however long they live, 80, 90 years, for them not to be able to say, this is too much for me and my family. I can't do this, and I don't want my baby to live like this. I think that really complicates things. And for us as physicians to not be able to talk to the family and to address those kind of things and to kind of ease that burden on them, I think would just be really, really hard for doctors. And I know that a lot of people that you see talk about aging and elderly, but as a pediatrician that works in an ICU with kids, this would be very, very, very hard for us. So with that, I would say that, as I'm not representing anybody, just me, and I'm a pediatrician, but I would oppose this bill personally. It would make my practice and my interaction with parents real hard if they have a kid that's in a situation like that. That's it. Thank you.
Do we have any comments or questions from anyone?
Oh, thank you. I'm very excited.
And be assured, you do not have to represent a group to appear before any committee. It can be individuals, or it could be a group. So we welcome comments from you and others. So thank you so much. All right. Do I have anyone else that would like to speak from the audience on the bill? Do I have any that spoke that would like to have a 1-minute comment? All right, seeing none, I'll come back to the chairman that brought the bill to us, and if you would like to have some comments.
Well, we heard from a few folks, and as I said before, it's a tough decision to make, and I'll be more happy to answer any questions, and be looking forward to working with the committee any way possible we know how to assist. So if there's any questions.
Any questions again from our committee members? Okay, certainly.
What are you doing to educate people on your bill, educate them on this process?
Well, I hope by the end of the day, anyone that leaves here will make sure they got advanced directive who is watching. But because we do see the vital importance, but education programs, I mean, that's something I don't have in the bill to address. It was just address that hydration nutrition point, but I think it should be something that is addressed to families, because I don't think we want to go into, when someone can't make a decision, to have a option for a decision-making process when we don't know what the patient really wants themselves.
All right. Does that?
Okay. Yeah.
Yes.
Thank you, Madam Chairman. Mr. Chairman, what is the penalty for doctors or facilities who would, in fact, withhold?
Good question, because that's where some of the bills, as I said earlier, I know you may not have heard it at the beginning, this bill went through a lot of transformations. They are held to a certain level, and this is where the trial lawyers could come in, maybe explain. There's some of the attorneys from MAG might be able to help, but when we first started looking at this bill, the way it was drawn, there could have been some areas that we were actually hurting the wrongful death statute in Georgia, and that was some concerns because Georgia actually has a very good wrongful death statute in place. So that's some of the reasons why we had to readdress the bill to handle that. So it went from criminal penalties up to 10 years in prison. It went to civil fines to now just a very short, straight to the point type bill. So we left all that out without touching the civil or criminal side of the current laws that we have now in the state of Georgia.
So am I understanding you that there is no recourse, no penalty? I
think it would fall under the wrongful death statute. That's why I was very careful on how we had to draft this, because if there is a wrongful death, then someone can be held civilly liable for that.
Representative.
Okay. On page 2, on LC 285434, it said a professional license of any person found to have knowingly and willfully violated subsection B of this code shall be suspended for a period of not less than 5 years by the professional licensing board issuing a license upon such finding.
That's one of the former bills.
Oh, okay.
Well, he's speaking from the substitute.
From the substitute.
Yes.
Oh, okay.
Are you okay?
All right.
This is a new bill with the LC number 285634S.
Oh, okay.
And that's where I was talking about. This bill has made many transformations over the months.
Any additional questions to the author of the bill? Thank you so much.
Thank you, ma'am.
Coming back to our committee, it would be the appropriate time, Representative Kessler.
Well, thank you very much, Madam Chair. I'd like to make a motion. If I get a second, I'd like to have a comment or two, if you don't mind, please. I move, out of respect to my colleague, that I'm sure that, well, I don't want to make a comment. I move that this bill be tabled at the present time, Madam Mayor. Madam Chair.
All right, I have a motion to table the bill, the committee substitute as well as the bill. Do I have a second? Second. I have a second. Now for discussions and comment. Representative.
You know, one thing I admire about, and I'm going to say the Republican Party, is that you guys are very careful about sending unnecessary mandates. I think if we send this bill, I'm going to have to side with you philosophically. If we send this down, we'll be sending down a mandate that we don't know really a lot about. I think the young lady and several people have come in and said that there are so many circumstances that I'm not in a position to know how to make the right decision, that I want to see that at least you have a chance to discuss this and we have more research on it, Tim. And that's my reason for tabling it. I think that this is something I can understand on an emotional level, how it's very, very important to people that are in this situation that are wondering if their loved ones are getting the best treatment, if there's any possibility of revitalizing a good quality of life. But I think if we table this, that we would be in a position to leave medical treatment and or medical decisions to those that are in better positions to know what to do than we do. So out of respect to you, I'm going to ask that this bill be tabled. Hopefully, if you have additional research and you have other people that are willing to work with you to make sure that we're not making a decision that we'll regret later, then I'll be happy to support you. So I'm not going to not support you. I just want to see the bill tabled so that we can do additional research on it.
Any other comment from our committee members? Seeing none, I call for a vote. All those in favor, please say aye. Aye. Those opposed, nay. The ayes carry it, and it will be tabled. I want to say thank you for those of you that testified today and came forward and brought your concerns. I would encourage you to pass information to us as a committee, as well as to the author of the bill, so that he will have that in hand if he wishes to continue in regards to the presentation that has been brought for us today. With that, any additional information or subject matter that needs to be taken up by our committee? Seeing none, this meeting stands adjourned.